Welcome to the 5th training session under the Technological Infrastructures Capacity Programme. Please enjoy this conference.
So it's very important to know that technology transfer must be done perfectly, if you can, but at least very good, and all the details must be very. So this is the index of today's lecture. We will talk a little bit about technology transfer. I am sure that everybody here and those who are watching us through streaming are aware of what technology transfer is. I will provide you with my own definition. We will talk about strategic thinking because I think technology transfer, when you deal with technology transfer, when you start thinking about technology transfer, you should have the first thought about your strategy, your path. Okay, technology transfer is just a medium. Okay, it's just a mean to an end. But you must be in a previous position with a strategic thought, and you should better have a very good idea what you want to achieve. You cannot just choose technology transfer as an option. You must choose technology transfer for a very clear and definite target. Okay, so we will talk about strategic thinking. And strategic thinking involves what I've described in this lecture. Involves 4 stages. When? Because you must know when is the ideal moment when you should start thinking about technology transfer, for what? The object of the technology transfer, how, of course, because as we will see afterwards, there are many different options for dealing with technology transfer, and of course the who, because all of you belong to academia, so you must deal with people outside. You must deal with entrepreneurs, you must deal with companies, sometimes you must deal with the government. So, who is very good? Okay? And after the lecture, the last hour, I will give you some examples, some case studies from different universities, and of course, we will open the floor to all your questions. And I hopefully it will be more dynamic. Okay, so IP management, which is the main object of technology transfer, is the key to support the innovation process. Well, the IP management is very, all of you already know that IP management is very important because IP rights are complex from the beginning and are complex throughout their own existence. And of course they are cumulative. You cannot deal with just 1 or 2 IP rights. IP rights overlaps and they are one on top of each other or adjacent. So you must deal with all of them, and IP management, of course, is essential. If you don't know what you have, you don't know how to protect what you already have, if you don't know how to discard what is useful and what is not, you will never be ready to start with your own technology transfer process. So it's essential to have your own department of IP management, and of course it's essential to hire somebody with expertise and with background in IP law and in IP economy to deal with your own. Okay, so IP management is the first step. As the photo says, state-of-the-art searches is of essence because many of you deal with innovation and study and publish papers and develop new processes, but at the same At that same moment, many other people all over the world is probably thinking about the same. So this is, unfortunately, this is usually a race. So you must always be aware of what not your competition, because this is not a competition amongst universities, but in the end is some kind of a competition. So you must be aware of what the rest of the universities study, what are their main projects, how are they doing that, whether they are publishing or not, whether they are filing new rights, etc. So state of the art is, searches of the state of the art is of essence, because sometimes you will know that your current investigation will not lead to a successful outcome, or sometimes you must readdress your search or readdress your investigation or choose another path, because you know, resources are limited and you're not going to waste all your money when you already know that you cannot achieve anything successful from the IP. From the IP point of view. Of course, it will be very successful to many of you, because you will be, it will be an award for your career. It will be a very important key point in your professional experience. You will publish some papers, but in the end, if you're dealing with the idea of producing something useful, something that can be protected, something that can be successfully sold and commercialized, then sometimes you must choose which path to tread on. Okay? As I say, it's a strategic source of information, of course. The market does not commercialize technology, but rather innovative solutions, that's for sure. Sometimes you will find very interesting investigations, very interesting lines of discoveries or so and so on. But if that's not useful to the outside world from the academia, it will be useless. Okay? So I understand, because as I told you before, I am a lawyer, and I understand what is your main purpose in life, in your academic life. But you cannot forget that part of your work is to produce something useful to the rest of the world. So you must balance that. Okay? I think approximately each year around 300,000 patent applications are filed, and around 30% of those lack of novelty. So that means that somebody already filed those, somebody already disclosed a very similar technology to the one that you have spent your money or the university's money in preparing the patent and filing the patent. So in the end, around 100,000 patent applications will be lost. And that's a lot of money, and that's a lot of resources poorly wasted. Okay? So I think that's very, very important, always to bear in mind why are you doing this and what is your main target. So, well, as I say in the lecture, well, key factors for preparing the value proposition are the analysis of the legal strength of the right. Okay, we will go further into that, because you are no lawyers, you have no legal background, but that is something you must be aware of. Okay. Identify potential uses and applications of the technology, for sure. Many of you will be dedicated or are dedicated to very abstract or theoretical lines of investigation, probably in the physics field. Many areas are just theoretical, and you cannot see or you cannot foresee any practical application, but you must make an effort. I know that many theoretical many theories, which are just theoretical right now, and you cannot find any practical application, will have some value in the future, so we cannot foresee that. But again, you must balance that. You must continue doing theoretical your theoretical line of investigation, but you must balance that with some practical applications. Otherwise, again, the resources will not be very well spent. Okay? Assess the degree of development. Of course, time in the academia is rather different than time in the market. Academia can spend resources for decades investigating. You cannot spend that in the market. It's not a problem of obsolescence, because you already know about obsolescence. We are in the engineering department of the Coimbra University, so you already know about obsolescence. But the problem is not only obsolescence. The problem is the market, the problem is consumers. So if you are not ready to produce something useful according to the market times, probably you will not make it. Okay, so that's something you must also take into account. And of course, the analysis and characterization of the corresponding market segments, well, that's rather difficult, because you are no experts in marketing, you are no experts in the real world, not because you are not in the real world, but you are in the academia, so you are not fully aware of what happens outside here. But we will see that afterwards when talking about the who, especially in technology transfer. But you must always have some connection with the real world and with the real needs. You already know that marketing usually creates new needs, so it's not always an accurate perception of what the market needs. But you must always have somebody with contact in the real world, so you can adjust your lines of investigation. Okay, so the process of technology transfer, I think all of you already know this. Researchers generate results, that's for sure. Research activities, that's what all of you do in your daily work. You have some technology transfers offices where all those results and all those research activities are gathered, okay, and processed. These technology transfers units usually have some contact with the real world, or they just disclose, or we will see that afterwards, but they just show what they have, okay, as in a fair. And usually external companies come to you. We will come to these technology transfer offices and find out what are you doing, and find out whether you have something interesting for them. So the real process will start. Okay, usually the technology transfer happens through any of these two options. In the vertical sense, okay, which, well, I would not say it's the usual one, but yeah, for the academia will be probably because the academia doesn't have the resources to really apply the ideas. So sooner or later you should find somebody that will develop your technology and adjust your technology to the real needs or to the actual needs of the public. Okay, you don't have factories. You don't know about marketing campaigns. You don't know how to price your product. You don't know the territory. You don't know the final consumer. So probably you will choose this option, a vertical option. You will find somebody, and you will externalize all those activities. But sometimes you will have to choose a horizontal technology transfer. Okay, you will find another colleagues from another university or another institute, and you will exchange your knowledge, you will exchange your patents or your lines of investigation. So some kind of technology transfer in the horizontal way will happen. So that's rather interesting, because usually you will deal with another entity that thinks rather equally as you, but sooner or later you will have to agree to find somebody in the vertical sense, because probably sometimes some universities, and I'm thinking about usually American universities, which are the strongest ones, they can do many things inside the university. Some universities, they have even factories, okay? But that's rather unusual. So when you deal with another university or any institute in the horizontal, in a horizontal relationship, sooner or later you will be forced to find a contributor in the vertical field. Okay. So, well, the essence of the technology transfer is the agreement. We will see that afterwards. But there are many different types of agreements. Okay, so that's one of the advantages of this field, that despite the I would say rigor of IP rights and the complexity of IP rights, agreements when dealing with technology transfer are very flexible. Okay, so there are many different ways to start a relationship with your counterpart. Okay, and we will see that afterwards. But these are the main categories. Well, the easiest one will be the sale. Okay, sometimes that's an advantage. I would say that it's not so advantageous to universities, but maybe sometimes you have some kind of technology or innovation that you don't want anymore. You cannot extract royalties, and you cannot exploit it by yourself. So sometimes you will sell that and just make money immediately and forget about that technology. So then you can sell that technology. Well, the queen category in technology transfer, of course, is licensing. So you will retain, the property of the IP, and you will authorize another party to use your IP in exchange of royalties, in exchange of money. Sometimes there will not be money. You can exchange another license. You can make a cross license. So you will not receive money. You will receive another authorization in exchange of yours. Okay? Sometimes that's interesting, but usually it's money. Okay? Technological development, technology transfer. You must look at technology transfer as a very long process. Usually when people think about technology transfer, they are thinking about producing an object or a service and selling that to the market. But there are some previous stages, and one of those stages is the technological development. Sometimes you will enter into into some kind of technology transfer agreement just to obtain a higher step to go further through some kind of technological development, because you need an authorization to access a different technology to make your own technology better. Okay, so sometimes you will enter into an agreement for that. Sometimes you won't have, you will not have the resources to go to another country or to go to another field where you don't have any expertise at all. So you will decide to enter into a joint venture with another company or with another institution who perfectly knows that territory, or who has extensive knowledge of that field. For example, maybe the engineering school of Coimbra will go into some kind of joint venture with, I don't know, medical school from Madrid or from Paris, okay, because that better knowledge of that field, which sometimes, in some way intertwines with your technology, okay? Or sometimes you just have some IP right or some IP development, and you need some the assistance of some construction company, for example. So you decide to exploit your own technology, let's say, into Brazil. So you must look for some company who has the expertise in developing your own technology in, I don't know, constructing bridges in Brazil. Okay, so you will enter into a joint venture just for that project specifically. Or sometimes you will start a spin-off. We will talk about that, about spin-offs. You just want to receive royalties. You just want to receive money to fund your subsequent projects. So you just want to extract money. So you create a new company, and you transfer all that IP that you want to develop or that you want to commercially exploit to that company. You let that company to perform in the market, and you just extract royalties, and you don't want to control or to really know what's happening. Just receive money. That maybe sometimes you can decide to use a spin-off for that. Another time you will have to acquire a new company or to acquire a new institution. So of course technology transfer will be involved. You will have to deal with the background, the portfolio that new company will incorporate to yours. So you must decide whether to purchase that technology, whether to create or to grant new licenses, cross licenses, etc. Sometimes you will have to decide, let's sell that portfolio and just get back the money to ease the acquisition or the merger, etc. We will see that afterwards. So, well, as you can see there, this is the usual path. The technology, which is your main role, the screening, which is start looking for what we do with this new technology. Of course, the market characterization and assessment. In the end, that search or that screening will be targeted against a very definite segment or very definite consumer field. A negotiation will start, and finally the technology will be marketed and sold to the consumers. Well, I think many of you we'll agree that traditionally the IP plays a defensive role. Many people think about IP rights as a vehicle or a mean to defend yourself. So in the end, IP rights are a monopoly, and as a monopoly, you can authorize who will enter into your field or not. So you can pursue and you can sue those who are using your technology without proper authorization. But especially related to the academia, but in many other fields, nowadays the IP rights are not just a defense or a shield, because technology evolves very quickly. As I told you before, everybody's investigating, everybody's developing. IP rights are probably one of the biggest opportunities nowadays in all developed countries. So you must think about IP rights as an instrument of collaboration, because sooner or later you will need somebody to assist you, or sooner or later you will need some other firm or some other company or some other university to help you and to exchange technology and to exchange developments. So sooner or later you will have to agree, sooner or later you will have to grant cross licenses or pay, etc. And that's the reality. You can think about a very, maybe one of your departments is or owns a very important patent, but sooner or later when that patent is put into the market, you will find many unexpected problems, and many of those problems involve IP rights of third parties that you were not aware of. I'm not talking about regulation, because many of you already know about that. You must deal with waste management, you must deal with eco and ESG values, etc. But I'm talking about, I don't know, probably a prior patent which is already enforced that you were not aware of. So once you have your own product developed and ready to be put in the market, you become aware that you cannot use that in some machine, because that machine is already protected through a patent. So you must purchase that you must purchase that machine, obtain an authorization to use your own product in reality. Because it's relatively easy to register a patent, file a patent, and successfully obtain a patent right for 20 years, okay? Which is not so easy is to put into practice that patent alone, because usually technologies are intertwined. And as we will see afterwards, when you start looking for, when you start doing a prior art search or a search of the state of the art, of course you find many patents. You don't know whether any of those patents are in use or not, but they are enforced. Sometimes they are not enforced, but they are already disclosed, so they can affect your own patent. So you must start looking for which ones are already enforced, if they are enforced in your territory, if the owner agrees or will agree to grant you some kind of license or some kind of authorization. We will not see that in this lecture, but maybe some of you have heard about standards. Standards are are closely related to telecommunications and electronics, and they are called standards for a reason, because they are related to patents, but the patent owner cannot exclude per se through the exclusionary IP right anybody, and he cannot, the owner cannot refuse granting licenses. So you must start, you must enter into some kind of agreement to obtain a license, and that's very cost expensive and time expensive. And as I told you, they are called standards for a reason, because otherwise nothing will work. I'm talking about Wi-Fi, I'm talking about lights, electronics, you know, the cables, etc. They're called standards for a reason. So when you decide to put your own patent into the market, you must think about all these things, because otherwise you can have a perfectly written and with a very extensive protection patent, but in the end, if you're not aware whether you can use it or not, the patent will be useless, completely useless. And it's a problem, again, of waste of resources and time. And, well, patents last 20 years, so it is really a pity to not be able to do anything with that kind of rights. And, but yeah, we will see that. We will see that. So, as I said, IP as a collaborative instrument, investment in IP, collaboration and technology transfer means accelerating technological and business development. I think that's pretty obvious, and I think all of you already know that. Otherwise, you wouldn't be here. Okay. Well, why technology transfer? I will not stop about in this. Well, obtaining an economic benefit from an IP right, well, monetization of IP, well, that's one of the usual reasons of technology transfer, just to extract money. It is not, I would say, an actual problem for many of you, because you are in the academia. But when you look further and when you look deeper, it is a problem for you, because your own existence depends on public resources, and if you are ready to convince not only the government and politicians, but the rest of the people, those who are not in the academia, that your work is valuable and you can obtain money and you can fund yourself in any way. I always speak about American universities. Of course, they are not a real example, because American universities in many ways are very different to European universities. But in technology transfer, they have found a perfect balance for that. They are very conscious of their own work. They know that they can only produce useful things. Otherwise, of course, they have some theoretical departments. Of course, they have some worthless or useless departments. Okay, but they can afford it because they have money. They have a lot of money, and a very important amount of that money comes because of their own technology transfer and because of their own IP production. So they can afford useless departments. It's not a problem for them. You cannot afford a useless department. Unfortunately, Portugal and Spain and many other European countries, and France and Germany too, they are richest, but they are not at the same level as the United States. You need money, and you cannot afford that. So I will insist on that. You must. Probably you have already changed your mind, because otherwise you wouldn't be here, but you must change your mind about that. You must really think about doing something profitable. I'm not talking about to transform the university in something capitalist or something just move just for economic return, because otherwise it wouldn't be the university. That's absurd. But you must balance that. You cannot live anymore in that very brilliant departments which just produce papers and just produce investigations, because it's not affordable anymore. That's a reality. We are losing our own competition against the United States, of course, against China, of course, against Japan, and we will see that in some, when we talk about the practical examples of some technology transfer produced from some European universities. But unfortunately, the level of our own developments in Europe could be much better, from my perspective. Okay. So, disseminate the technology to a wider group of users. That's for sure. Allows a third party to have access to that technology through a license. I think that's obvious. It allows the company developing the technology to subcontract the manufacture or distribution. I already spoke about that, and that's, well, I think that's obvious, because the university cannot and should not manufacture anything or sell anything. That's not your purpose. And well, due to its intangible nature, it can be used by many licensees. Well, yeah, that's one of the advantages of IP rights, which are intangible. So you can authorize many people to use them, you can transfer them, you can chop them, you can distribute them through different individuals, through different companies, through different territories. We will see that. But there are many things that you can do with IP rights, and that's I think that's very interesting. Well, market pain. I will not stop about in this screenshot, but well, market pain, as I told you before, is the realization that after all your efforts, after all your years investigating, you have produced something absolutely useless. Maybe not per se, but maybe because of the reality of the market, or because of the reality of the competition. Okay. Well, the investment in IP rights protection without valuation plans, the return on the research and development investments. That is something you should not be really aware of, because nobody's going to ask you about how much money did you spend on this and how much money are you expecting to obtain through selling this product. But of course, it cannot be worthless. Once again, you must balance that. Okay. Of course, in a company, if you don't have a higher return on that than your own investment, you will be fired immediately, or you will go bankrupt. Okay. So that's an advantage for the academia, but you should be concerned a little bit about that. Well, the emergence on the market of more competitive, innovative products. We have already spoken about that. Product differentiation. Again, all these are market strategies that, of course, you are not currently aware of, but you should start thinking about when you start dealing with a potential collaborator or a potential associate in the technology transfer. And usually it is a company, a private company. Okay, so, well, get permission to do what you would otherwise have no legal right to do. I think this is of essence for anybody. Unfortunately, in IP rights, not many people agrees with that, because all of you, me included many years ago, have downloaded films or music or things like that, but all of us are adults and professionals, so yeah, we should think about obtaining authorization. You cannot use third parties' technology or knowledge without authorization, and that is something that is somehow strange in the academia, because you share knowledge, and knowledge should be free, and knowledge should be accessible to anybody, and you should be able to consult another repository of foreign university and extract some information and send an email to another investigator. Yeah, you should be able to do that in the academia. But you must be aware that that knowledge can transform itself into technology, can transform itself into IP rights. So you must really be very conscious and very, yeah, and really think about what you are sharing, whether you can share that at this moment. Maybe you can share it afterwards, but not at this moment. Maybe you cannot disclose that because maybe you can lose novelty in your future patent, so you cannot disclose that. You cannot answer that email. So you should start thinking about some protocols and some some guidelines when disclosing your own information and disclosing your own developments. And that can also help you to understand when you receive some refusal from some of your colleagues from other universities, okay? Because they are thinking the same as you, okay? Protecting their own technology. Well, I think we have already spoken about this, so I will pass to the next one. Okay, strategic thinking. Well, as I told you at the beginning, I have structured this strategic thinking into 4 stages: when, what, how, and who. Okay, when, yeah, sure, that's the beginning. Okay, ideally you should start thinking about technology transfer at the very moment you start studying and investigating into some new project. Okay, probably that's unfeasible, but you should be thinking, okay, maybe this this investigation leads to nothing, maybe it will lead to a successful patent. I think you should, sooner or later you will, this will be applied automatically, and you will start applying all these tips and all these advices to any line of investigation. But I am aware that you cannot do every day, and you cannot do that with all things. But think about it. Think about the when. Okay, we will talk about that afterwards. Of course, the what, the technology, that's your main task, to identify the technology. Okay, because you are the experts. Of course, the how, the agreement, and the who, the terms and conditions. Who, terms and conditions, and of course, who will be your partner. Okay, terms and conditions usually define your own partner. Okay. So when? Well, you can choose when you have something valuable that can be or could be commercially and successfully exploited. You should think about some kind of competitive bidding. Okay, so how do you disclose, or how do you make the rest of the world aware of your own technology? So you can do that through advertising. This is something pretty common, okay? When you have some technology which has been properly secured, and when I say properly secured, as all of you know, in the example of patents, you cannot disclose anything before filing, because otherwise you will lose novelty of your own patent. But once that is properly secured, maybe you can choose some kind of advertising. Okay, we have filed this patent. We are in the process of patenting this technology. And are you interested? Can we start discussing terms and whether it is maybe you are attracted to this technology which has not been already patented, but maybe you can help us throughout this process because we have spent money. Usually academia has very low fees and sometimes no fees when filing, but the process of patenting is long, and in many times the process of patenting involves low-key litigation because you must deal with the office, with some problems with the claims, with some problems of the extent of the patent. Sometimes a third party files an opposition against your own application. Sometimes you must attend a hearing before the patent office, and that's expensive, and you need a lawyer, and you need a legal counsel to advise you. So maybe you can advertise that application of that technology and ask for help. So maybe you can fund, a third company can fund that if they find it maybe reliable, or maybe it could be a successful technology, so you can obtain funds that way. Maybe you have a pool of patents, or maybe you want to start a pool of patents, or maybe you want to speak with another university or speak with another institution and include your own patent in that pool because you don't have the strength. Well, the University of Coimbra is a very well-known university in Portugal. I think it's a very well-known university for Spaniards, but maybe it's not so well-known in Denmark, for example. But Denmark has a very good pool of patents dealing with, I don't know, solar technology or wind technology, okay? Because many companies rely on some developments of the Copenhagen University. So you have developed some kind of wind technology in a patent, and you can ask the Copenhagen University to include your patent in that pool, because that will increase the probability, your probability, or your chances to obtain a license agreement, for example, or to sell it, because of the strength of that pool, okay? Or sometimes you can make a bundle of licenses through a pool of patents. You can include your patent into a set of 4 additional patents, so the cost of the license will be lower. I don't know, maybe. So a pool of patents could be an option. Submission of applications is a kind of advertising, but let's say that you have your technology and you are just looking for a partner, and you say, okay, send me your ideas and we will choose, because we own the technology and we want to choose a partner. Send us your applications. And sometimes this is more common in America. In Germany it was in the past. Nowadays I don't think so. Maybe you can grant an award. Maybe you have that technology and you just grant an award, let's say a free license for, I don't know, 5 years or 1 year, to the most innovative or the most interesting application of that technology. So it could be, all of these are examples of of ways of disclosing and making public your technology to the world. Because in many times you will not know what to do with that. And that's a reality. You don't know. You don't know. You just have developed this technology, and okay, what can we do with this? Let's disclose it, and we will find out if anybody's interested. Okay. But other times you, because of prior experiences or because some of your professors have left the academia and started a company or something like that, you already know who will be your ideal partner. So a non-competitive bidding may start. So you already know the who, and you should start the negotiations. And usually these negotiations start through a non-disclosure agreement. I think all of you have heard about this, and probably many of you have signed some of these. It's a very common, well, sometimes people is very frightened about NDAs, but it's a very common contract. It's a very simple contract. It's just a confidentiality contract. Okay, the parties agree that while they are speaking or while they are negotiating, all the information exchanged will remain confidential. And that's all. An NDA is a very, very simple agreement, a very powerful agreement, but a very simple one. And sometimes you already know, or you already have some ideas about how you want to exploit the technology or to use the technology. So maybe these ideas are very broad, very basic, but you already know those. So you can also introduce, or you can also draft a letter of intent. So you set some kind of rules. Okay, we want to use the technology just in the medical field, for example. Yes, it can be applied to, I don't know, to space or to roads, but we want to use this just to medical field. Or we just want to use this technology just for this kind of disease, for example, or just for vaccines, something like that. Okay? So you set a very broad set of rules, and then you start negotiation. So you make a frame. You frame the relation, and you just start. You make the skeleton of the relation through a letter of intent. That can be very useful because many times the partners are very happy, and they forget about these details, and sooner or later problems arise because some misconceptions and some wrong ideas which were not said at the beginning. So this letter of intent can be very, very useful. Okay? Okay, the what? Well, the what, I think, is as I said before, is your main task. You must evaluate, and I think all of you, probably many of you know about the public resources to do that, search of the state-of-the-art searches, prior patents, public information from patent offices, from other investigation or technologies institution, etc. Okay, so and of course, if you cannot do that, you should hire an external consultant to do that. Okay, that's one of the. I wouldn't say the most usual service we provide in our firm and in many other IP firms, but it's very common to use, to provide searches, to provide what is called sometimes an FTO, freedom to operate service. Okay, just to clear the field, to know whether this is, well, this can happen, okay? So, of course, you must enter into a confidentiality agreement, but that's obvious for the reasons I told you before, because you don't want to spoil the relationship. You want the relationship at the beginning, since the beginning, to be comfortable. Okay, so you must enter into a confidentiality agreement, but after that you must conduct a due diligence on the IP rights, on your own IP rights, of course, because you want to be, as we will see later, you are giving assurances to your partner. You are giving guarantees to your partner that the technology you are offering your partner can be used, has not any encumbrances, has not any problems with third parties, with other rights. And if it does, you want to disclose those encumbrances to your partner. You want to be clear to what you have to offer. Maybe you have a fantastic patent, but you must inform your your partner that this patent can only be used if you obtain an authorization from another patent owner. Well, that can be a problem, that can be not. It is your problem, but it's also your partner's problem. So you want to be as open as it can be possible through these searches and through these FTO investigations. Okay, so that's why I say in the caption, assess the risks associated with the use of the licensed IP right. Sometimes you must evaluate your own IP right for pricing purposes. I think that's related to dependencies on other IP rights, because of course that will increase the ideal price, either for a royalty, either for a sale. Let's say the usual example is the iPhone. The iPhone, I think, involves around 200 patents inside. So Apple must have a very, because probably none of them, or only a couple of them, are proprietary of Apple. But in the end, the iPhone is an Apple product. So Apple must obtain licenses, maybe some cross licenses, and pay, and final price of the very expensive iPhone, of course, involves many royalties and many authorizations of different patents. Okay, so of course you must assess through that due diligence about the correct pricing of your IP rights. And finally, review the legal requirements for the formalization of the purchase-sale contract. Well, usually this is a very, or it has a very minor impact in the final price. I'm sorry to say that we lawyers are expensive. We are not so expensive. But usually it's a very, it has a very low impact. But you must, you must take that into account, because in some cases you will use, and it happens with NDAs, you can use templates. Many of you probably use templates. Let's download this template from the INPI, or from the European Patent Office, or from some colleague of mine, or some previous agreement we signed some years ago. We can use that. Yeah, let's just change the names and change the date. Okay? But if the technology transfer involves serious assets, you cannot do that. You cannot take that risk. And probably your partner will not agree to that. So that's another thing you must bear into account, legal expenses. Okay. Well, confidentiality agreements, a very short review. Well, of course, their main purpose is the exchange of valuable information. Sometimes it's not so valuable for the other party, but it is for you. Maybe some people who work with you on a confidential basis and you don't want anybody to know that about, okay? Maybe some locations that you want to remain secret, and so on. But in essence, an NDA is for the exchange of valuable information, okay? I think probably many of you know about this, but I want to focus. I want you to focus into this idea. Confidentiality is one thing, and trade secret is another thing. Okay? All trade secrets are confidential because they are secret, but not all confidential information can lead to a trade secret. I will not develop further into what a trade secret is, because probably you know that, and that will be the subject of another lecture. But in essence, between the parties, you can make everything confidential. You just declare it is confidential, and it will not be a problem. You just say inside the NDA, this is confidential because for me this is confidential, because I don't know, if I just take a coffee at 10 a.m., well, that's confidential information. I just take a coffee at 10 a.m. It's not a problem, it's confidential. But that cannot be a trade secret, okay? So those are very different things, okay? NDAs are very important for the protection of novelty. Patents and designs, of course. Designs and patents, well, they are very different, but they share the requirement of novelty, okay? And as all of you know, you can harm or affect or destroy the novelty by almost any disclosure, any kind of disclosure. Many IP laws, and I think the Portuguese industrial code has an article for that, have some definition of which disclosures are not harmful to novelty, but those are very exceptional. Okay, so and sometimes very difficult to meet the requirements. So you must be very concerned about disclosure. Okay, because an email, a letter, I don't know, of course a paper, sometimes a public lecture. Let's say with your own department, just a very informal talk someday in a class, or that can destroy novelty. So NDAs are perfect for protecting that, okay? Of course, you cannot conduct yourselves every day through NDAs because you speak freely with many people, but you must always be concerned about the destruction of novelty. Okay. Life and afterlife. Well, NDAs sometimes are difficult to understand because NDAs rule the disclosure of confidential information while the NDA is in force. Let's say the parties expect to negotiate through a term of 1 year. So the NDA will rule for 1 year. So all the information, all the confidential information exchanged throughout that year will be under the scope of the NDA. But that's one thing. So once the year ends, the exchange of information will not be subject to the NDA, but the NDA will remain in force. And that means that all that information exchanged throughout that year will remain confidential, and probably for life, or until the moment, with the other party's authorization, the information is disclosed, or when the moment arrives that that information becomes public by legal means or by other means. Okay? But that's one thing. So the NDA lasts 1 year, 2 years, 3 years, 1 month, and it applies to the information exchange through that term. But the NDA will exist probably for life. Okay? Sometimes the NDAs just have a life of, I don't know, 5 years after the last information was exchanged. Well, let's say 5 years, okay, doesn't matter. So after those 5 years, the information exchange within that term will be public, or you can freely disclose it, okay? But usually NDAs are for life, okay? Because you cannot really you cannot really know when that information will be worthless to you or useless to you. So it's better to agree to an NDA for life. So when you see an NDA for life, be relaxed. It's not a problem. Okay. Usually agreements are not for life. Okay, licenses are not for life. Rents are not for life, etc. But NDAs are. Okay, it's a special kind of agreement. Okay, and the easier the better. Sometimes NDAs, and if you have dealt with American universities exchanging some kind of information for your own researches, sometimes NDAs have 6, 7, 8, 20 pages. And in my point of view and in my experience, that's ridiculous. Okay? An NDA can be perfectly useful with just 1 page. Okay? As long as it comprises the idea that all the information, all the exchange information between the parties remains confidential, the NDA will serve its purpose. Okay? You don't need more clauses, you don't need more definitions. I think it's really useless, but sometimes you will have to deal with that. But for your own researches and for your own relations with third parties, your NDAs ideally should be as limited as possible, okay, as short as possible. Material transfer agreement. Well, this is another this is another kind of contract. This is very well, I think for engineering studies and engineering research, it is used, but it is mostly used for chemical and pharma services. Okay, a material transfer agreement is a kind of confidentiality agreement, but related to not to information, but to an object, to a material sometimes, and that's why it's very used in pharma, because sometimes you want to do some research on a material or on a molecule or something like that, or but you don't have the means, and you must hire a laboratory, maybe outside abroad, and you must send a sample to perform some investigations or some researches into that material, and you don't know whether that material can be patented or not, and maybe you want to treat that material or that composition as a trade secret, or maybe you want to treat that material as confidential, okay? Or maybe you don't know whether that material, after the research made by the laboratory, can surprisingly have a new property, and that maybe could apply to your own field, to the engineering field, because when the product is in raw, you have not found any property to that, but once the laboratory has done some investigations and has performed some activities on the material, you find that, well, it's perfect for, I don't know, for building something, okay? Or it has a level, an unexpected level of resistance. I think something like that happened with the graphene. So you want to enter into a material transfer agreement, and you want to reserve your rights. You hire a laboratory, but just to do that for you, because you don't have the resources. But if new IP rights appear, you want to be those new rights to your property. Okay? So you should enter into a material transfer agreement. And probably the laboratory will ask you to sign that material transfer agreement, because the laboratory or the other institution would like to have a part of those rights, probably. So you must, well, it's a very interesting kind of agreement. It is not so often used, but just bear in mind that it's the same as an NDA, but related to materials and objects, okay, not information. Okay, licensing versus sale. Well, I think many of you know what is licensing. I always like to offer a different version of what a licensing is, which is some kind of counterfactual, because all of you probably know that a license is just an authorization to use somebody that is yours, okay? So I usually like to say my own definition. A licensing is really the way that I refrain myself from suing you, because that's unauthorized use. So I'm not authorizing you. I'm just refraining myself to suing you, because you should not be using that, so you pay me. Okay, it's the same. It's the same. But it's just to change a little bit the common idea of what a licensing is, because in the end, this is the same as the fines. When you pay a fine, let's say because you parked your car in the wrong place in the street, or you didn't pay the ticket for the time that you must stay your car in the street. In the end, you are just paying a fine just to commit a crime. So sometimes committing a crime has a price. So when you pay a fine, in the end, you have committed a crime by paying. So sometimes licensing can be seen as that. So you are paying me just for me not suing you, okay? Well, so that's the usual way of transfer technology, licensing, because you retain the property. This is very useful when you want to develop further technologies or continue your patenting path. For example, you just have a base patent, but you want to retain the ownership and all the rights because you want to build some other technology on the top of it and file new patents on the top of it. And that's important. It's important to retain the property, because otherwise your own behavior could be infringing, or your own behavior. Well, this happens, for example, this happens when in the pharma field, and that is why it's a legal authorization, a very specific one, when you want to develop the generic version of the drug. If you want to develop the generic version of the drug, you must perform some investigation and some analysis on the drug itself. But doing that is a patent infringement, because you are not authorized to perform anything on the drug. You are not authorized to use the drug into a laboratory and study it. Yes, you are authorized to do that because there is a specific provision in the law authorizing you to do that, but just for pharma and just for develop the generic version of a drug. Okay? But for the rest of patents, you are not authorized to do that. Okay? Maybe, let's say, fertilizer. You have a patent for a fertilizer. You cannot perform any investigation on the fertilizer. Okay? Because otherwise it would be considered patent infringement. So you must obtain a license. If you don't license, if you sell the fertilizer, the patent for the fertilizer, but your department in your university continues that line of investigation, maybe sooner or later you will be infringing, because you have lost all the rights when selling the patent to a third party. So you cannot perform more research and more experiments on that fertilizer because you have lost all the rights. Or sometimes you can sell the patent, but you can negotiate to retain some kind of authorization to do that research. Okay? But you must bear in mind, because sometimes sale can be useful, sometimes licensing can also be useful. Okay? Well, as I have explained before, advantages and disadvantages. Of course, when you sell, you have immediate financial compensation, and that is, many times that is very tricky, because if you want to sell your own patent the best or at the best price, you must also consider not the current price and all the investment and all the money you spent on developing your patent, but also the expected return and the expected money that party will obtain through the exploitation of that patent. And that is very difficult because you cannot see the future. And of course you cannot be too greedy, because otherwise the purchaser will not purchase your patent. Okay? Because the purchaser is looking for a profit. Okay? So it's very tricky selling a patent at the right price. Usually, because you cannot see the future, usually you will be happy with just recovering all your expenses and just a plus, okay? And that should be your profit, okay? But sometimes that is not possible, okay? Well, licensing, on the other hand, is advantageous because you receive a continuous revenue. Okay. Usually sometimes licenses are just a 1-year license, just one fee, or a 5-year license. But usually licenses are on installments. Okay. Sometimes on a monthly basis, sometimes on a year basis, whatever. But you receive money on installments. The problem with licenses is that you depend exclusively on the performance of your licensee. So this means that you don't know how much money you will receive. You know the percentage of money. Because, well, sometimes you grant a license and the royalty is a flat fee, let's say, 1,000 euro per year. But that's not so usual because you don't want to lose any opportunity. If you are really, if you really believe that the product will be successful, you don't want that. You want a percentage of the sales. But the disadvantage of that is that you depend exclusively on how the licensee performs itself. So you depend on the marketing of the product, you depend on the strength of the licensee pushing the product and selling the product, you depend on the own structure of the licensee in the company, its own team, etc., the salaries, etc., the territory. So, as you can see, there is no an ideal way of transferring the technology, and this must be dealt on a very specific case-by-case basis. Okay, as I told you before, many of you think about technology, probably think about technology transfer as a license, but it is not. There will be many times where selling the technology will be the best option, or selling the technology, retaining some authorization to do your own research, etc., will be a very good option. So, well, those are the advantages and disadvantages. Business models. Well, general principle, as I think I have explained, it must be simple, okay, for all the events, for the whole territory, for the total duration of the patent. When you transfer technology, as I told you before, with IP rights, you can fragment technology rights. Okay, you can choose the territory, the extent of the authorization. You can either choose an exclusive license or non-exclusive license, etc. But that can lead to a very high level of complexity. So you should deal with your own IP right the simplest way. Okay, you should choose an exclusive licensee if that suits you. Okay, otherwise, yes, you can choose non-exclusive licensee, but then you should not fragment the territory. You should grant the non-exclusive license for all the territory, for everybody involved. So you should not segment the territory. Let's say one non-exclusive licensee is authorized to operate in the north of Portugal, another one is authorized in the center of Portugal, another one is just authorized to operate in the islands, etc. Okay, and it can operate as a independent entity, and some other times it cannot. Okay, so maybe you are thinking about, okay, we will start a negotiation. Speaking on behalf of the Coimbra University, but Coimbra University is not the legal entity owner of the rights. So you must, of course, do some research about that, because you might be thinking about the university itself, but it's not the university, it's the engineering department, which I don't know if it has some legal entity per se, but sometimes they have, or this institution, this Institute of Technology or something like that, okay? And again, sometimes you can be dealing with a company, but it's the mother company, okay? But since you are looking to use the technology in Spain, you should sign the agreement with the Spanish company. Maybe, I don't know, maybe you should sign it with a mother company, but you might be speaking with a mother company, but the legal rights will be transferred to the Spanish company. So you must be really aware of who are you talking to and who will be signing. Okay, so sometimes those are different. So bear this in mind, because you don't want to be surprised. And of course, you don't want to have an agreement that can be void or that will not help you by any means. Okay? Of course, set out the grounds for the agreement and provide for interpretation. Well, I think we have already talked about that. Include a list of definitions of the terms. This is pretty common in the United States. This is pretty common in the United Kingdom, all the common law countries, because they don't have civil law, and they must clearly set the definitions and the scope of the agreement in the own agreement, because they cannot rely on the law itself. Okay, they rely on the legal precedent, which is very different to our interpretation of the law. So sometimes this is useful, sometimes it is not. But yeah, maybe some terms are useful. Again, this is useful in the common law territorial area, because contracts for those countries are very lengthy. They can be of 20, 25, 30 pages. So, of course, definitions are very useful, because once you know what the definition of patent is, you don't have to, you can easily pass through the pages, okay? In Portuguese or in Spanish or in French agreements are not so long. So sometimes definitions are not so useful. Okay, but of course they are not a nuisance. They are not a problem. So if you want to include a set or a list of definitions, it's not. It might be useful. Okay, but you shouldn't worry if you find an agreement without terms and definitions. Okay, of course the scope of utilization rights granted. Well, yeah, what we spoke about before. The extent of the use, whether it will be used for manufacture or production, whether it will be used for distribution, whether it would be used for research and development, as we explained in the material transfer agreement, for example. Well, the type of licensing, whether it is exclusive or non-exclusive, I think it's rather easy to understand. Exclusive, you are the only one authorized to do that. Non-exclusive, you will share this technology with other competitors. Okay, and sometimes not equally. I can grant non-exclusive licenses, but one licensee will have better conditions or more advantages than the others. Okay, okay. And that will be a private agreement. That will be a relation between you and me. Okay? So the state, the patent office grants protection for a territory, and you decide how to deal with that territory. And you decide who will be doing this in this area or in this other, or in this city, or maybe in this street. You can do that. Okay? Of course, that implies another level of legal issues that we will not talk in this lecture, that relate to competition issues and to market issues and other problems with restriction of competition, etc. But just keep this idea that one thing is the extent of the right, which is always connected with the country, with the territory. And Another topic is how you decide to fragment or segment that territory, according to your needs, according to your market expectancies, or whatever. Okay. What you cannot have is a Coimbra patent or a Miño patent. You cannot have that. You can define that territory within your patent, but you will have a Portuguese patent. Okay. Well, about the compensation. Well, as we spoke before, and when the technology transfer involves money, you can choose. Well, the parties can agree how to pay for that technology, to pay for that authorization. What is more usual? Generally speaking, what is more usual is to receive first a fixed amount, some money, okay, just to perform as a kind of deposit, let's say, so you can feel or you can know that the other party takes this business seriously, and then agree some type of installments according to a royalty. Sometimes it will be a fixed amount, sometimes ideally should be a percentage of your sales. Okay? So that's what upfront means, or milestone payments means. Okay? The relation with licensees, when you grant a license, and especially when you deal with top technology, you are dealing with companies which have a very good knowledge of the field and a very good knowledge of the technology. So ideally you should expect that your partner sometimes will be brighter than you and sometimes will be more intelligent than you. And of course that should be your target, to choose a more intelligent partner than you to exploit your technology. But that has a disadvantage, that your partner might develop something new on top of your technology, or something that is very closely connected to your technology. And probably some type of discussion will arise. So who owns what, to what extent, and if possible you should foresee that in your agreement. You should set some kind of clause that says, okay, if you licensee develop some new technology in this line, probably, well, I could agree that you will retain full property. Or maybe if you develop some kind of technology in this field, well, let's say you should retain 80% and I will take 20%, something like that, okay? But whatever you agree, my advice is that you should foresee that. It is not real to not think that your partner will just remain quiet and will just remain inactive regarding this technology. Your partner, for sure, will be developing new things, and we will try to profit and to expand and to improve this technology, or to create some side projects to that technology, and it will relate and it will connect to your own technology in many ways. So you must foresee that, and you must be prepared to discuss about that, because you don't want to lose any chances. And of course you don't want your partner to take advantage of you, of course. So, well, the licensor must guarantee the ownership of the licensed IP rights. Well, that's of essence, because if I am authorizing you to use something that is mine, I must assure you that it is mine and that it will remain valid
for the time we are collaborating. Okay, so I must pay for the annuities of the patent. I must pay for the renewal of the trademarks, etc. I must defend cooperation in case of violation of IP rights. I must defend the right, the IP right, either because some party will try to invalidate it. I think many of you know that patents can be invalidated because sometimes the office considers that the patent is valid, but a competitor or a third party decides that your patent is not novel or it lacks of inventive step, so it wants to challenge your patent, or sometimes that party doesn't want to challenge completely your patent, but just to restrict the scope of your patent, so that company can perform in the market or use its own technology for free. So when you enter into an agreement with a licensee, my advice is that these events must be perfectly foreseen. So if the patent is invalidated, who should defend the patent? Who should bear the costs, the legal fees or the legal costs of defending the patent? And at the same time, maybe the patent is not challenged, the validity of the patent is not challenged, but the patent is infringed, or the technology is used without authorization. Who should be defending that? Who should be pursuing that legally? And who, of course, who should bear the costs for that? The licensee, the licensor, should it be half by half? So that must be foreseen somehow. I know that it will be difficult and it should be analyzed on a case-by-case basis because many things can happen, but at least some base guidelines should be set in the agreement, okay? Because that happens. And ideally, you should have a license agreement for many years. The better license agreement is that that lasts as long as the patent does, 20 years. Okay. So, of course, the duration of the agreement. Usually, you should start with 1 year, 2 years, and if things go well, to extend that agreement. But sometimes you want to have a 5 years agreement or 10 years agreement, because the technology that the patent involves is bright, is excellent, is marvelous. But your licensee needs to do some further research because there's not a viable product yet ready for the market. So it needs more time. Of course, define the law governing the agreement. That's another usual problem, and especially for a country like Portugal, which is very small. It will be difficult for you to find partners inside Portugal. So you will be looking for partners in Germany, maybe in Brazil, maybe in Spain. So you should also define very clearly in the agreement what will be the governing law. The governing law means that the law that will be applied to that agreement. So you can choose the most advantageous law for you. Ideally, it should be the Portuguese law, okay? Because your assets are here, because your money is mostly here, because of the language, etc. Okay? But maybe, I don't know, maybe for some kind of technology, the US law is better. I don't know. That should be studied on a case-by-case basis, but I can confidently say that many of your agreements should be ruled by Portuguese law. But if you are dealing with a German partner, your German partner will say, I don't agree, I want German law to be applied. So you should discuss what law must apply to the, to the agreement. Sometimes that is feasible, that is easy. Let's say, okay, I agree to Portuguese law, but I don't want to go to Portuguese courts because I live in Germany, or I live in Denmark, or I live in Japan. That's too much money. So if there's some problem between us, I want you to be sued before Tokyo courts. And that could be a problem for you. Because of course nobody thinks that it can be sued by its partner regarding the agreement, but that happens. So it can be very expensive to discuss or to enter into a litigation before Japanese courts, even applying Portuguese law. So that's another level of discussion for the agreement. And sometimes it's very important because legal expenses can be a really effective deterrent for discussing things and for discussing terms. Sometimes the partners, the affected partners say, okay, right, you win. I accept that because I don't want to be sued, or I don't want to sue you before a foreign court. It's going to be more expensive. And that's unfair, but that's practical, of course. So it's a very important thing that sometimes universities fall to properly analyze because they are eager to sign an agreement. Okay, no, never mind. Yeah, U.S. courts, okay. Pennsylvania High Court of Justice. Pennsylvania High Court of Justice. Are you thinking about... So, have you thought what would be the expenses for Coimbra University to start a litigation before Pennsylvania High Court of Justice, or, I don't know, California Court of Justice, Los Angeles, I don't know. Have you thought about that? Oh, but this is an excellent agreement. But, okay. But speak to your lawyer, speak to your legal department in the university, and assess the risk of that decision. Because that can compromise in the future your agreement. And it's a very important issue to be aware of. Okay, how? Joint venture. Well, joint venture is not so common in the academia field, but sometimes it's useful. And it's useful because a joint venture is a very a specific targeted collaboration between two parties. And it's targeted mostly to a very specific market or to a very specific country. Joint ventures, and I think with this example many of you will understand this, joint ventures are very common when a company is bringing some business from America to Europe or from Asia. This is very common in restaurants or in franchises. I don't know, Burger King, McDonald's, etc. So you act through a joint venture. You know the domestic market. I know this develops and this works very well in my domestic market, but I don't know the foreign market. So I must look for a partner who has a very good knowledge of that country or of that region. So I enter into a joint venture. And we agree to exploit and to use or develop the technology in that country. Okay? So, as I say in the slide, commercial partnership between two or more independent entities to execute a common project or achieve a certain objective. Okay? Well, both parties share risks and contribute their intellectual capital to the development, production, marketing, and commercialization of technology. Once again, you can picture yourselves or see yourselves as the strong party because you own the technology, but without the proper knowledge of the territory and the proper knowledge of the consumers, your technology is worthless. So maybe you are not the strong party, even owning the technology. And sometimes you need a joint venture because you need somebody who knows the territory, who knows the details of the market. Okay? Again, it's essential to determine the ownership of the results. Okay? Sometimes there are results created. I think in many times there are not, but it can happen. The essence of a joint venture is not, generally is not to develop new things, but it can happen. It's just to adapt and to adjust your technology to the territory and market segment needs. Okay? And finally, the joint venture can take two forms, either as a model agreement, okay, or giving rise to the establishment of a new entity. Usually, at least in my experience, the joint ventures usually create a new entity. But that's for many reasons, which we will not develop here, because it's strictly legal, but it really has relation with taxes, employment, etc. So it's better to create a new entity, and that new entity should do business in that territory. Okay, but sometimes you don't need that, so you just take enter into an agreement, and your partner, who knows the territory, starts doing business in that country. Okay. For example, I think in Brazil. Brazil has many legal problems to foreign companies. You must always do business in Brazil with through the hands of a Brazilian company or a Brazilian advisor. So you will always need somebody from the country for doing business. So maybe you can enter into a joint venture with a national company, or you can create a new national company to do that. Okay, well, joint venture agreements. In joint venture agreements, you must also decide about the entry of new partners. This is not so common, but sometimes, because the market can evolve and peculiarities of the territory, well, maybe a new partner can join. So you must set in the agreement how are you going to deal with that? Okay. Of course, the departure of the project partners, maybe the joint venture is not of your interest anymore, so you want to remove yourself. How are you going to do that? Are you going to sell your option? Are you going to look somebody to replace you? Are you going to dissolve the joint venture? So that's something that you must also foresee in the agreement. Insolvency of the parties. Sometimes you find a very good partner, but business doesn't go as expected, so it becomes bankrupt. Are you going to help him paying? Are you going to assume the debts? Usually a joint venture has some kind of committee for managing the IP rights, okay? Especially if it involves technology, because it happens, the relation between the partners in a joint venture sometimes is similar to a license or licensee, okay? Because Somehow you are going to deal with your partner as the licensee in that country, okay? So once again, the parties should discuss about the management of those rights, and of course the maintenance of those rights. I have already talked about that, and it's very similar to what happens in a license agreement. Okay. Well, advantages: resource sharing. Well, of course, you don't know the territory, and your partner doesn't own the technology, so it's a win-win situation. You are going to share your resources. Synergies, of course. New markets, risk minimization, development of new high-tech products. Well, this can happen, this cannot. This is an option for joint ventures. But once again, if that is expected to happen, you should define perfectly who will own what in the future. And reducing difficulties in obtaining finance. Well, yes, that's an advantage because you are dealing with a national company. So maybe you as a foreign company will have more difficulties because you don't own assets in that country, and your partner does. So it can be an advantage. This is very advantageous. As I put the example of Brazil, but it happens in many countries. Of course, there are preferences for national companies rather than foreign countries. Okay, there are many countries that are more closed, and very more restricted. Okay. Well, disadvantages: communication and objectives. Well, yeah. The problem here is that usually your partner wants to open a new market. He knows the market, he knows the territory, and he wants to profit of your technology. So yeah, communication and objectives is very important, because otherwise sooner or later there will be problems with your partner. Different cultures and management styles. Well, yeah, that's always an issue, because when you are dealing with a foreign company, if it's a European company, well, there are not many differences between Portugal and Spain, but if you are dealing with a Russian company, maybe, and if you are dealing with a Moroccan company, you will have many different problems, and many of them not related with the technology, many of them related with culture. Okay? Of course, expectations. Different levels of expertise and investment, work and resources distributed unequally. Well, yes. As I told you before, many joint ventures are seen as a licensor licensee, so the licensor just remains latent and waits for collecting royalties, and it is the licensee who does the hard work. In a joint venture, sometimes it can happen, that can happen, okay? So you should foresee that and set very, very well-defined the roles of each party, okay? And the freedom or lack of freedom. Yeah, this is a joint venture acts as a couple, so you must always support your partner and also suffer the problems of your partner. So yeah, it's not the same as if you are doing business by yourself, but I think that's obvious, the lack of freedom. Okay, spin-off. This is the most usual structure for a university, and in essence, the essence of a spin-off is that universities were not built and are not prepared for doing businesses for themselves. Okay, so they must create some new entity to do that, and these are spin-offs. It's a new company with a commercial mind, with a commercial target, which is very closely related to the university, but it's a business entity. Okay, so the university has influence, has some kind of control on the spin-off, but in the end the spin-off is a commercial entity, and it will have its own future and development, and sometimes its own end. Okay, but it's not the university. Okay, this has some advantages, of course, and some disadvantages. But probably the biggest advantage, and I think it's a win-win, is that the university is not affected in its own image. It's not seen as I told you before, no? As a business-focused entity, which universities should not be. Universities should be the world of academia, investigation, and knowledge. Okay, so it's a good solution for a university. Many of your professors, many of the members of the of the committees and directors, etc., are not prepared, are not ready, and are not willing to do business. Okay, so spin-offs are also a way to select and to choose those of you who are ready to do that. And that's why many of you, if not all of you, have some contractual clauses about what you can do during your term, whether you can do business or not, if you're a professor or not, etc., whether you can earn money aside from your own professional work in the university. Okay, so you can work, for example, in a spin-off. And also the spin-off can benefit of that relation with the commercial world. Okay, so new partners can enter, can form part of this company, or this spin-off can grant licenses, etc., or look for new partners. So the concept and objective, business initiatives promoted by members of the university community aim at exploring new processes, products, or services based on the knowledge acquired and the results obtained at the university itself. So as I said, the spin-off is a way to put those, or to put that knowledge into work. The objective, technological development to the final product, transfer of results to the market and value creation, obtaining an economic return. So, once again, due diligence to protect the knowledge provided. I think I have already explained that. You must choose what to do with your knowledge and what should be transferred, assigned, licensed to the spin-off. Okay, and of course the partnership agreement with a third party. Okay, this is important. There are two kinds of spin-offs, and that should depend. The choice should depend on the project of the university or the technology involved. The university can assign the IP. Okay, so the university has a technology that is suitable to be used in market. So a new company is created and the university transfers all the IP rights. So the university loses control, loses property on the IP right. Of course, this is not ideal per se, because as I explained before, you are going to lose all rights on the IP. You will not be able to continue your research and development on that IP or side IP because you will lack of rights and you will lack of authorization. So The solution is to be an important or a relevant part of the spin-off. So that way, even if you are not the owner of the IP right as a university, you control what the spin-off does. Okay? So the spin-off owns the IP, acts by itself, but the members of the board and the shareholders, the majority is owned by the university. So in the end, the university is performing a very effective way of controlling what the spin-off does. This can be a little bit problematic because, as I said before, the university is not ready and it's not willing to do business by itself. So one thing is the shareholders' proportion, which is the majority, and the other thing is letting the spin-off to act freely, because otherwise it cannot be, it cannot perform properly in the market. So sometimes it is a problem because the other partner has a minority shareholder, the minority of the shares, sorry, and it's going to be a problem because you must assure your partner that it will be acting freely. Okay? But it's a solution, the spin-off. So you control what the spin-off does with the technology, whether licenses are granted or not, because in the end you have the majority of the shareholders. Okay? And the other way of acting with through a spin-off is via a license. Okay, so the university retains the ownership, grants a license to the spin-off, and the spin-off acts as a licensee. So the university retains property and just receives royalties. Of course, the disadvantage is that you can put some restrictions in the agreement to your licensee, of course, but in the end, you must give your licensee as much freedom as possible, because otherwise the licensee is not going to see that business as profitable. So again, when you create a spin-off and you grant a license, you will be facing the same advantages and disadvantages as that we spoke about regarding license agreements. Okay. So who? Well, I'm assuming that we are in a license agreement, which is, as I told you, the most usual. The licensor will be many times you, but many times you will be the licensee, of course. The licensor, as I explained in the slide, if it's an exclusive license, it means that you are the only one authorized to do that. But sometimes, as it happens with the property, as I explained before, and the research activities, you are not willing to be a competitor of your licensee. So you are okay with granting an exclusive license, but you want to retain some activities to you. Okay? Maybe you want to not only do research, but you have a very small line of marketing activities. Let's say you have, for example, let's say you have some kind of technology that involves the manufacture, the knitting of some t-shirts or shirts or garments. And you grant that technology to an exclusive licensee to produce a viable product to be sold at the shops. But the university wants to retain some activities to sell its own t-shirts, for example, for the University of Coimbra. So You grant your licensee an exclusive license, but you retain some activities to you. Okay, that can happen. Otherwise, if you don't state that in the agreement, the law says, and I think the Portuguese law says the same, that you cannot do anything, despite you are the proprietor or the owner of the IP right. So that should be important. You should think about whether you need to do something with the technology. And even if you have an exclusive licensee, you should agree with that licensee about those uses reserved to you. Okay? Well, the defense of the patent against acts of counterfeiting or infringement, we have already spoken about that. Damages, defects inherent to the invention. Well, this is problematic. For the universities, it's not so, because since I think most of universities, if not all, don't have manufacture capacity, defects or problems with the product will not be an issue. Okay? But sometimes the problems with the products are related to the patent itself or the technology itself. So damages, compensations, problems with insurance, etc., should be, of course, discussed in the agreement. Of course, the right to receive royalties, we have already spoken about that. The right to conduct an accounting audit and inspection of the licensee. Sometimes it is useful. Of course, the licensee is not going to see that in a very amicable way or friendly way, and that could mean that you are suspicious. Okay, but sometimes your licensee is not telling the truth completely, is not disclosing the invoices, is not disclosing the proper sales, etc. So sometimes you should reserve your right to conduct an audit, whether the ledgers are okay, etc. Okay. Of course, as a licensor, you must maintain the validity of the patent. Usually, this is not very expensive, but of course, it will depend on the amount of technology transfer. Of course, that is your duty as a licensor and owner of the IP right, but that doesn't mean per se that you must pay for it. You can ask your licensee to pay for that, but you are obliged, legally obliged to do that. So if you fail to pay the annuity or you fail to file the proper paperwork to maintain the patent, you will be liable against your licensee. Your licensee can claim, can ask for damages because if the patent is lost, the licensee falls. Okay. Ensuring peaceful use on agreed terms. Well, I think that's pretty obvious. Account for its validity. Yeah. When you transfer technology, I think we already spoke about that. When you transfer technology, you assure that the technology is useful, is valid, doesn't have any encumbrances, doesn't have any problems, doesn't have any conflict with prior technology. Of course, you must say that on a bona fide basis, and you must have made the best as you could to find whether there was any problem with that technology. But it can happen that, as it happens with the validity of patents, even if the office has granted the patent, that some years later somebody challenges the validity. So it can happen with your own technology that, well, your technology was not so free in the end. So what happens with that? Who should pay for that? And how is it going to affect my agreement with you? So you should foresee that in the agreement. Of course, the allocation of rights of technology improvements, we have already talked about that. The communication of the know-how. Yes, sometimes there is know-how related to patents, okay? And sometimes that know-how is useful and sometimes that know-how is not useful. I will explain. When your main activity is to research, it is expected that many of your patents will not have many know-how involved because you are just producing patents and patents and patents, okay? So you cannot transfer any know-how to your partner. Then, if you remember some slides ago, you must look for a partner who is ready or who is willing to do further research to find out how to use this patent in the field. So there is no know-how attached to that patent, at least at this moment. The know-how will belong to your partner because your partner will be the one looking for ways to use this patent in the real world. But sometimes, because of your experiments or of your research in your laboratory, etc., you will have some know-how attached to that patent. And of course, you must transfer that know-how because it's essential of the patent to be put into practice. Okay? And the ways to transfer that know-how brings us back to NDAs, confidentiality agreements, etc. So one thing is the license of the technology, and other thing is the transfer of the know-how. They are related, but they are not the same, and it can be problematic because many times a patent license without know-how is useless, it's worthless. Okay? And technical assistance for use and application. This is very closely related with the know-how. Okay, the licensee. Of course, the licensee, the first duty is to use the patent. You must use the patent or you must use the technology and pay me. Because if you don't use it, if you don't exploit it, I'm not going to see any return, any economic return. So I can revoke the license. Okay? Of course, the remuneration, maintain quality standards. Yeah, this is another usual requirement for licensees because you don't want your technology to be affected by a bad image because your licensee can change, or you can grant more licenses. Maybe if you have a non-exclusive licensee and you're looking to expand your market, if your licensees are performing badly or are giving a very bad image of the technology, it is going to be much more difficult for you to find new licensees and to obtain more economic returns. So, yes, your licensee should maintain quality standards. Of course, confidentiality, we have already seen that through the NDAs. Sometimes you transfer technology, but you also transfer trademarks or images or signs or other IP rights. In the case of the University of Coimbra, maybe your licensee is interested in obtaining some authorization to use your seal or to use your name because it will improve the sales, it will give a very good image to that product because it's assured by the University of Coimbra, etc. So you should also include those additional licenses in your main license agreement. Of course, again, the audits and of the accounts, the assistance, this is related with the know-how, assistance in the defense and the enunciation of any act of infringement. Well, it is your partner, your licensee, who knows the market and who is always discovering or finding competitors who are pushing him or who are pushing this technology or are pushing this product or are taking advantage of it. So your licensee is your eyes in the market, okay? And of course, the licensee has the right to be informed about the status of the IP right. Any problems with the application, any problems with the title, any challenges filed against the patent, etc.
This is the end of this session of the Capacity Programme for Technological Infrastructures. We thank you for your participation and look forward to seeing you in the next.